Good morning, ladies and gentlemen. I'd like to start by thanking the Francesco Lauro family and indeed the wider family of the Studio Legale for inviting me here today. I see I've already, I thought I'd already spoken for a minute, but my 10 minutes hasn't actually started yet. Somebody has to press the start button. But I'm going to use my slides as a mere sort of backdrop as I go through my brief comments, if I can make sure I've got the right button. Yep. I just wanted to start by telling you that my theme is really state aid and short sea shipping with a bit of general background. But my experience perhaps doesn't recommend me to the audience, because I was just remembering on the way here that about 10 years ago I did a lot of work for P&O ferries in the days when they had state aid clearance for a scheme run from the Spanish port of Bilbao. And of course, you can readily understand, those of you from France and Spain, that, and indeed from the UK, that Brittany ferries and P&O ferries are very direct competitors. And so in our spare time, we used to lodge complaints against Brittany ferries, which unfortunately didn't get quite so far as Brittany ferries' appeal against our clearance decision in the European Court of First Instance, which unfortunately I had to stand there like this in front of a British judge. Our juge rapporteur was the British judge in the Court of First Instance, now called the General Court. And he said, well, where's the evidence in the Commission's file on looking at the effect on competition of the ticket regime that the Bilbao local authority had run in favour of P&O? Bilbao bought 1/3 of P&O ferries' tickets and then handed them out free to their citizens as a form of social aid. And unfortunately, neither the Commission nor myself could find any evidence in the file where the Commission had considered the effect on competition. So we lost, and that was that. And on the other hand, we could never quite persuade the European Commission to look seriously at Brittany ferries and, as I understand it, the multitude of local authorities that actually, in effect, fund or support by purchasing the vessels and equipment for Brittany ferries. Whether that is state aid or not is perhaps a moot point. Anyway, not very good credentials, I'm afraid, on state aid. But even worse, I thought I'd better ask the question, what is European state aid law? So I brought the answer. This is 800 pages, currently available on the DG Competition's website, to tell you what is EU state aid law. Now, I'm not going to do that in the 8 minutes that remain to me. I'm going to just quickly explain to you that the way it works is that there are treaty provisions. Article 107 of the treaty prohibits unlawful state aid unless it is automatically exempted under paragraph 2, and that is a whole list of different forms of aid. Social aid, like the tickets that weren't ultimately considered social aid, is one of the classic examples. And then the more complicated area of discretionary exemptions. And the key procedural point is that you cannot have your aid exempted unless the government notifies it to the European Commission. And one of the main problems for the beneficiaries of state aid is that if the government won't notify it, and these days, believe it or not, I'm doing a state aid case in the UK where we're trying to persuade the government to notify the aid in order to get clarity for particular investors. They take the view, no, we don't want to deal with cases that aren't terribly complicated, and won't notify. Now that actually puts the companies concerned in a very difficult position, because you can't notify yourself. And we discovered that again in one of the P&O ferries cases, where the European Commission turned round and bit us in the foot by saying that you, the law firm, had notified the actual state aid application and not the government, which was merely a fact that we had delivered the package to the Commission, and unfortunately it had some indications of our law firm's address, etc. on it. But that's the sort of complications you get in state aid. So you have the treaty, you have individual exemptions, and you these days have block exemptions, which don't really impinge too much on the shipping sector. So I'll hasten to there, although they do cover research and development. You have what's called a de minimis provision, which says if the aid is very small, it's not unlawful and you don't have to get clearance for it. And then on the maritime front, you have the guidelines for maritime transport that Alphonse mentioned, and it's very adequately summarized by reference to tonnage tax and employees or seafarers' reductions in social payments. But what is perhaps more interesting from the point of view of short sea shipping, and there's a section on short sea shipping, is that the new investments to take containers or take cargo off trucks onto the sea may benefit from up to 30% of state aid for a new service, and indeed the alternative is that 10% of transshipment facilities, which is the same as what is available in the internal transport context, that also may be subsidized. But there are various conditions which you can see in these guidelines that apply. But I want to come now, finally, to what perhaps is the most interesting point for this discussion today, and that is the Tirrenia case. And I've been asked, of course, to be controversial, because that's what lawyers are supposed to be. I know very little about the Tirrenia case. I feel totally innocent. I'm on neither side. I'm totally up for hire, as the taxi driver says. But the position, as I understand it, is that the Italian government decided to privatize Tirrenia, no doubt, I think, at the expiry of a state aid clearance decision issued in 2004 by the European Commission. That decision, just to pause for a moment, cleared the state aid that supports the public service obligations or public service contracts that the Tirrenia Group operates between the various islands and Italy, but it actually required repayment of certain aid which was related to purely commercial business. And I think, in fact, those of you from Greece may remember it actually, I think, considers the trade between Greece and Italy as not being covered by the public service obligations. So the current position, as you'll all know better than I do, is that in August there was nearly the completion of the sale of Tirrenia, but it actually didn't come to fruition. And the company was put into administration, and the special administrator is actually, at this moment, I suspect, trying to choose who to sell the business to. I understand that the deadline is the 20th of October for this decision, and many of you in the room will know the answer. I don't think I can say very much more than what the 2004 European Commission decision said. And one message that I really wanted to get across to you today, and Tirrenia will no doubt be an interesting test of this, is that the control of state aid was shifted very recently from DG Transport to DG Competition. Now, I can finally tell you about a case, I've got 54 seconds left, which I'm still involved with for 12 years, where the French government sought to privatize a company owned by SNCF, and after failing to find a purchaser, found a purchaser, albeit probably not independent of the parent SNCF, and gave them €100 million to walk away with this business, for which they paid €1. Now, DG Transport cleared that, but subject to various conditions. It's still now pending before DG Competition, and I doubt very much if they'll take the same view. Thank you very much.